This book, it's an inside job. It's a book that describes how law operates within the EU's key political institutions, the Commission, the Council and the European Parliament. As EU legal scholars, we have all learned to think that the EU law evolves around one institution, the European Court of Justice, which of course scrutinizes and makes sure that the EU institutions they comply and stay within the treaties. My argument in this book is that most of the key legal interpretation, it takes place within the EU's political institution. Very little is known about these processes. They are hidden from sight and highly confidential. But the key people in these processes are the lawyers that work for these institutions. The book, as I said, it's an inside job. It builds on my own experiences from working in these processes, but also nearly 70 interviews with lawyers and policymakers working in the EU institutions. In the book, I describe who the EU lawyers are, what they do, where they come from, what motivates them, and also how they see their own role in the democratic processes, but also the construction of Europe. In the book, I argue that the meaning of law comes largely to be defined in these political and bureaucratic processes. Law is very flexible, and if the political climate is favorable, almost infinitely flexible. With the right legislative techniques, which these EU lawyers of course master, most points on the agenda of EU institutions can be realized in the end. This doesn't of course mean that the court is entirely irrelevant, but what the law is seen to require is based on a risk assessment that takes place in the political institutions, the risk that a matter is appealed to the court, which of course then stresses the importance of finding a political compromise that everyone can live with. And of course then also the risk that if appealed, the court might actually annul the measure. Most of the work of EU lawyers is routine, but their role matters the most when the EU faces a crisis. Those are the moments where great legal creativity is routinely needed and where risks and alternatives gain very little attention. These are also the measures that provoke criticism among EU opposition and that have merited critical scrutiny in national constitutional bodies, including that in my own country. The question then becomes, can the EU define the limits of its own powers? And if not, what those limits are and who gets to define them? This is a very fundamental question of EU law. Clearly, I don't think that the letter of the law should always win, but I do think that the processes in which key decisions on the future orientation of the EU are decided are today, they're not open, political and democratic enough. When the EU operates in the legal grey zone, this should not be a confidential matter, but an open process where also the risks and options are brought to an open debate.